I call the honourable member Tracy Martin.
Kia ora, Mr Speaker.
Kia ora.
I rise on behalf of New Zealand First to speak on, and the title of the bill on the table is actually the Copyright Parallel Importing of Films Amendment Bill. The bill it is altering was originally called the Copyright Parallel Importation of Films and Onus of Proof Amendment Bill 2003. I have some questions as to what has happened to the onus of proof part of the original bill and how that will be addressed with this amendment. But perhaps that will be dealt with at a later time. Mr Speaker, New Zealand First supported this legislation at its first introduction in 2003. New Zealand First supported the Act's retention in 2008, just as we supported the Copyright New Technologies Amendment Act, which also includes a 9-month ban on copyright infringement. But times change, and inside the world of digital technology, times change very, very quickly. If I can just make sure that we all understand what the original Act did that we are amending here this evening. The provisions of the original Act meant that no one, other than the producers of a new film or their licensed distributors, were able to import into New Zealand any copies of that new film for a period of time following its public release anywhere in the world. This law covers all commercial films regardless of their format. Private individuals were and are still able to buy these films in whatever form via the internet from overseas and bring them in for their own use. The restriction on parallel importation was and is directed essentially at commercial distributors. The original 9-month period in this legislation, there is a 5-month period suggested, for new films was selected as an appropriate period within which copyright owners and cinema operators could derive an economic return on the cinematic release of these films. Now, New Zealand First wishes to acknowledge that it is recorded that film exhibitors employ approximately 10,000 New Zealanders directly, and indirectly another 21,000 New Zealanders gain employment from contributing industries. We want to acknowledge that a major driver for this staggered protection was the viability of cinemas, and perhaps more specifically, my apologies, for the protection of rural cinema owners. And New Zealand First most certainly supports all those in our very stressed rural economies. Much of this viability was based around the fact that the major film producers in the US, as has already been mentioned, released their new films in time for the US summer, spring or Thanksgiving breaks. These do not directly align with the New Zealand school term breaks, where the maximum of audience participation happens. And this is where historically cinemas have made the profits that sustain them over the quieter weeks of the year. And it's during those quieter weeks that they show New Zealand films such as This Way of Life and have film festivals. And it would be a concern if cinemas closed or chose not to show the sometimes less profitable New Zealand films, as this would have a downstream effect on that section of our artistic community. The definition of films covered by these measures relates to those intended for commercial release, having been specifically amended during its original passage to exclude films intended for educational distribution. The 2003 legislation had a sunset clause provision which enacted in 2008. The Act was renewed by the Labour government with another sunset clause of October 2013, hence why we're here today. Now, coupled with the delay to parallel importation is or was a provision to protect against the imports of counterfeit films, sound recordings and computer programs. Infringement would occur if the importer knew or ought to have reasonably known that the imported item was an infringing copy, a counterfeit copy. The onus of proof of copying was reversed at the 2003 introduction, with imported copies being presumed to infringe in the absence of evidence to the contrary. It is up to the importer to prove that the parallel imports are not pirated copies. Where has that protection gone, or is that protection being retained under the original Act, even while this new one amends? So if we could have clarity on that, that would be really great. And this is part, unfortunately, of the problem of only just seeing the legislation and not having an opportunity to discuss this deeper. So this part of the legislation, this protection around counterfeiting, was essentially technology-driven. The ability to mass-produce identical, perfect copies at the push of a button made it much harder to distinguish counterfeit copies from genuine copies which have been parallel imported. New Zealand First wants to recognise that both of the areas covered by the original Act still have merit. This was witnessed, as I mentioned earlier, by our clear support for this legislation in 2003 and 2008. But is it now necessary, is the question. New Zealand First sees print media comments along the lines of cinema attendance numbers have shown strong growth in recent years due to the explosion of multiplex venues. When we look at rural cinemas to gauge its survival, we look at examples such as the Matakana Cinema Complex that services my local community, or the Te Awamutu Regent Theatre with its investment in a new screen which gives sharper picture and 3D format projection equipment. We see the innovative way that film exhibitors have risen to the challenge of DVD and Blu-ray, remembering that the current Act has never stopped a New Zealander from going online to purchase copies of new release films from overseas for personal use and to view in their own homes. New Zealand First believes that through the initiatives such as IMAX, 3D showings and the exceptionally civilised introduction of premium showings, where large comfortable chairs and outstanding glasses of New Zealand wine are available to an appropriately mature audience, cinemas have created a sellable experience that may now be countering what were very real dangers to their viability back in 2003. As a mother of 3 teenagers, I would also go so far as to say that it could be argued that it is the DVD manufacturers who now have to create a point of difference for this generation, to compete with the cinema experience, which is now, to many of today's younger generation, just as it was to the generation of the 1950s and the 1960s, the place to go with mates. In my research for this speech, I spoke to students from the 1960s, who told me of going along with a gaggle of mates and sitting through 4 movies in a row after a day of study at Auckland Uni. I recognise in that story the number of times that I have ferried my own 15-year-old son to the local cinema to meet up with his gaggle of school friends, where they watch a Sunday movie and then adjourn to the neighbouring ice cream parlour until ready to call the mum and dad taxi to collect them. We will be interested. We will be very interested, if this bill passes this reading, to see the Select Committee report and their conversations around these topics. And should this Act gain enough support to pass first reading, we would suggest that the Select Committee consider Section 35(2)(b). This section stipulates that the courts must not require a defendant of copyright infringement charges to reveal its source of product in circumstances where it would be unreasonable for them to do so. In normal court proceedings, Mr. Speaker, for copyright infringement, revealing the source of the product would be an expected outcome of the discovery process. For the conflicting reasons verbalised above, New Zealand First will be abstaining from voting on this bill.
Mr. Speaker.
I call Kemaljeet Singh Bakshi. Sat Sri Akal.
Sat Sri Akal, Mr. Speaker. First of all, I would like to pay